Hello everyone. I hope you all are doing well and in good health. I am Aqib, a student of law at International Islam University Islamabad. Currently, I am in a final year. So today I want to be start meditation course with you all. So in the first lecture, I will discuss with you about the alternate dispute resolution. So in the very first scenario, I have to give you about the introduction of the uh, alternate dispute resolution. The traditional courts litigation system has long been central to justice. However, over time, serious problems have emerged in the court system. As a result, many disputes are now resolved outside the court through mediation and other ADR mechanism. There is a Chief Justice of United States, Warren Burger, that criticized traditional litigation as the too costly, too slow, too destructive, inefficient for modern society. So the lawyer should act as a problem solver and peacemaker, not just adversarial fighter. So the historical background of alternate dispute resolution, or the historical background of mediation, is that the ancient and cultural roots of mediation is that mediation has been used historically in many societies. In Confucian's philosophy, mediation is considered the best way to resolve disputes. Litigation was viewed as a failure of social harmony. So the example for this is that the China. In China, community mediation committees resolve millions of disputes yearly, while in Japan, litigation is seen as a last resort, and the early America, mediation used especially in labor disputes. The institutional development of the mediation is that in 1930 in the US Department of Labor was empowered to mediate labor dispute. In 1947, the Federal Mediation and Conciliation Service was created to handle industrial dispute. So the mediation winning in the dispute resolution marketplace. So when the civil trials have significantly decreased over the year, example in 1961, it's about the America. So well in 1961, 11.6% of cases went to trial. Meanwhile, in 2008, only 1.8% went to trial. This decline shows that ADR methods are replacing traditional litigations. Reason for decline in trials are that number one is that overcrowded court dockets, and the number two is high litigation cost. Number three is that long delay in courts. Number four is that destructive adversarial nature of trial. These are the reasons for the decline in trial. And problems with the traditional courts that uh, overcrowded. Number one is that the overcrowded dockets. There has been a huge increase in lawsuits. Courts are overloaded with civil cases, criminal cases, regulatory disputes. Extensive discovery procedures also slow down the system. And number second is that soaring cost of litigation. Litigation is extremely expensive. Only wealthy individuals or insured parties can easily afford proceedings. Costs include attorney fees, expert witnesses, discovery, trial preparation, and in the number three, what comes is that inordinate delay. Court cases can take many years before final judgments. A delay increase financial and emotional stress for parties. And in the number fourth, destructive nature of adversarial system. In the adversarial system, encourage hostility, conflicts, personal attacks. Often, the process damage relationship between the parties. And number on the other reasons for decline of courts trial is that the court judges encourage settlement before trial, and the legislatures, those are the governments, promote ADR programs in mediation and summary judgments. Courts increasingly resolve cases through summary judgments, reducing the needs for trial. And then number four, arbitration provides a faster binding decisions. And the number five, multi-district litigation. Complex cases are consolidated to improve efficiency. And problems with the adversarial legal system is that the parties must agree to battle litigations based on confrontation and winning. And system is rigid and inflexible. Courts follow strict procedures and rules. And the encourages vindictive behaviors. Parties sometimes use litigations to punish the opponents and seek the revenge. And these are the things that vulnerability to abuse. Examples includes contingency fees arrangement, fee shifting provisions, consumer class actions, limitation of court remedies. Courts usually provide only monetary damages, legal judgments. However, many disputes require other solutions such as apology, continued business relationship, confidential settlement. Mediation can offer create solution beyond monetary compensation. And the criticism of mediation is that despite its benefits, mediation also faces criticism. In the number one, treats the jury system. Sometimes some argue mediation reduce the role of juries. And number two, no role to appeal. Mediated settlement are usually final. Number three, risk of unfair outcomes. Parties may accept less than the true value of their case. And the number four, lack of transparency. Mediation is confidential and not public. Mediator bias. Critics argue mediator might favor repeat player like insurance companies. However, mediator have no authority to impose decisions, so neutrality is necessary for success. And number four, other ADR mechanism are that the ADR include both non-binding and binding method. Non-binding ADR is that negotiation, non-binding arbitration, ombudsman, moderate settlement, and settlement conference, early natural evaluations. And the binding ADR is that arbitration, rent a judge, mini trial, summary arbitration, high-low arbitration, baseball arbitration. These are the examples of binding ADR. And the hybrid ADR methods that these combine mediation and arbitration. Example for this, that's when the mediation is done, then people go for the arbitration. When arbitration is going on, then people go for the mediation. These processes are known as the hybrid ADR process. These methods allow parties to first attempt settlement and then obtain binding decisions if necessary. Developing a systematic ADR programs. Organization can develop ADR program through these steps. First, they have to identify conflict problem. Number second, conduct a conflict audit. Number three, they have to set goal and objectives. Number four, appoint a high level person to manage ADR system. At the number five, provide proper funding. At the number six, use timely ADR intervention. And number seven, create a database to evaluate ADR results. And these are the things that are the must taken away. So the traditional litigation system is expensive, slow, and adversarial. Meanwhile, ADR mechanism, especially mediation, provide faster, cheaper, and more cooperative solution. A lawyer should act not as an advocate, but also as a peacemaker, helping parties resolve disputes peacefully. This is all about the first lecture of introduction to ADR, alternate dispute resolution. I hope this will be helpful for you to learn about the ADR. So thank you so much for watching this video. I am thankful to you.